happy to be back here. And thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also Twitter. And I'm happy to tell you that you can also participate in this webinar with us. But before we move ahead, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, thank you so much for joining us today. And we've got a great session lined up for you. And today we are diving into a topic that's vital for many businesses and workers across the United States, the H-2 visa program. And so, whether you are a business owner seeking to sponsor seasonal or temporary workers, or a worker instead in learning more about your options, this webinar will be invaluable. And I'm really thrilled to be welcoming our guest for the first time on Immigration and Jobs Talk Show, none other than Megan Kirkner, who is the founder of Kirkner Law PLLC. With nearly a decade of experience in immigration law, Megan has become an expert in H2A and H2B immigration matters, and she'll be walking us through everything today you need to know about legally sponsoring workers and also exploring the processes of working as a seasonal temporary worker in the United States. So yes, I think you can go grab a pen or paper if you're still the old school, or maybe even note down some pointers in your tab or your phone or your iPad. Thank you so much for joining us, and let's get ready to really learn some key highlights today and these insights that Megan is going to, share with us. So, Megan, thank you so much for joining us today. Really happy to have you here.
Hi, great to be here. Thanks for having me.
Yes, Megan. I don't know if the introduction was enough, but we would love to know you much better. Please tell us about yourself and how busy you are these days.
Sure, like many immigration practitioners, it's a hot time. There's with unemployment where it is, everybody is just looking for people to fill empty slots. The H-2B and H-2A realm is just extremely busy. I service employers all around the U.S. In both H-2A, which is agricultural, and H-2B, which is non-agricultural workers in the seasonal temporary visa process. Been doing immigration for over 10 years now, and you know, it is a hot segment right now, and we're all on pins and needles with the U.S. political climate, and just hoping we stay busy.
We are. I already feel it is, and especially with the elections just over just some time back, and everything
Yes.
changing right now. And in the next coming months, we are going to see a lot more
Mhm.
changes. I think there's a lot
Yeah,
on our plates, on everyone's plate. So,
very much so. A whole another segment for that.
for sure, Megan, for sure. And today's topic. So, what can folks out there expect from today's webinar from us?
Sure. So today's focus is really going to be on the H-2B side of the seasonal worker program. The agricultural H-2A side, it would have to be a whole nother show. But what you should learn, how an employer would get involved in the program, whether or not they would qualify, how the process looks, what the risks are. Um, what compliance components they need to be aware of, what workers should know and what they should know their rights are in the process so that they are not taken advantage of. So um, really just trying to focus on giving a little background knowledge from start to end, on the employer side, and touch on the, employer rights side as much as we can.
We will. And I'm sure folks out there are very excited as well. So happy to tell you that you can participate wherever you're watching us. And if you have any questions, especially regarding the topic, please feel free to drop them in the comments. And Megan is definitely going to be very happy to take them up later in the show. So I'm excited too, Megan. Thank you so much for doing this today. And
Sure,
without
happy
further
to.
ado, I have a few questions lined up. So let's go ahead with the first one.
Sure.
So, what are the key steps an employer must take to obtain a temporary labor certification from the Department of Labor for H-2B workers, and what documentation is required?
So, just as a little bit more background, the H-2B is a full-time temporary non-immigrant visa. It is seasonal. So unlike many other visa types, it's something you have to apply for every year. Unless you're doing a one-time need, that's a separate category for like a nanny or a caregiver. That would be for up to 3 years. The rest of the visas, the bulk of the H-2B process, for your hospitality, landscaping, seafood industries, construction industries, those are seasonal or peak load, meaning it's an annual application. It involves 3 separate government agencies. That's Department of Labor first. We'll get into what that entails in a minute. The USCIS, U.S. Immigration Services, is the second agency, and the third would be Department of State. That's the consular processing. So that's where the worker would come in, and that's at the point that they would go get their visa. The first step in the process is critical. One of the key compliance components of this program is that all workers are paid at least a prevailing wage, which is mandated by the government. It's to ensure that they're receiving a fair wage based on the type of position they're working in, and the location and experience required for that position. So, it just really ensures that the program maintains its integrity and no one's being paid something that's too low for what they're working on. That's the first step in the process. All of these steps in this process can be time intensive. So it is very much sensitive to what part of the year you're applying for, what your dates of need are. So this prevailing wage step takes up to 60 days sometimes. So you really have, for all parts of this process, you need to allocate at least 6 months. You need to know at least 6 months ahead of time in order to ensure you have enough time to file with each agency. The way the program is set up is that there's 2 halves of the fiscal year. So that if you're based on your start date of need. So if your start date of need is in October, you'd really start prevailing wages more than likely in April, so that you can file in July. You file your H-2B application, which is an ETA 9142B. That's the second step in the process. Once you have a prevailing wage, you can start that process. And again, if you're at April 1st start date or later in the second half of the year, it goes by the government fiscal year, which starts in October. My apologies. You will need to start that process probably in August of the preceding year. If you're looking for instance, starting an H-2B worker April 1st, 2025, you're going to need to have already started that process. It may be too late at this point to get a prevailing wage back in time to start the process for next spring. That being said, once you've gotten that prevailing wage and you file the second step in the process also with Department of Labor, that actual H-2B temporary labor certification, that would require you to set forth with the government whether you're filing for one-time needs, seasonal, or peak load. So that would entail documentation if you're a new filer, a new employer, establishing your seasonality, establishing your season and your need for the number of workers you're requesting. Typical documentation would be a statement of need, which again explains your business, your season, your industry. Taxes for the company, could be revenue charts, payroll showing when you have workers. Those are very common documents, as well as contracts. Really what you're showing at this stage is that your business operates either seasonally, meaning you only operate during the times that you're telling the government you operate, or that you're peak load, meaning you operate year round, but there's a peak, there's an objective increase in your business or revenue during particular months of the year. That would be your season. So all of those kinds of business documents can prove that seasonality, prove that temporary need. Now, that application gets lodged with the government on one of 2 time periods, depending again on your start date of need. It's either July 3rd for October 1st filings, or January 1st for April 1st filings. There's technically a 3-day filing window that you have at the beginning, but it starts on January 1st and July 3rd, unless it's a leap year. So that's when you file that application. The next step, after you actually lodge the application with your supporting documentation, is your company will be, this is what they talk about when they talk about the H-2B lottery. All of the employers are put into a pot in a computer and randomized. Your company will be assigned a group letter, A, B, C, D, and so on and so forth. And while that letter or that group doesn't truly dictate whether or not you get workers, it's more nuanced than that. It does impact the timelines, and more so for the spring visa half than the winter. That letter will determine whether you beat the cap from in all cases, for the most part, for the spring. It's there's enough employers or applications for the number of workers in Group A, for instance, in the spring to encompass the entire cap. So if you don't get it, that's not to say that if you don't get Group A, you're not going to get workers. We'll get into it later in the program over what the cap is, if there's other ways to get in under the cap or other mechanisms to file with supplemental visas. We'll talk about that in a little bit. But assuming you get in and there are still visas available to file the next step. The next step is filing with Immigration Services. You take your certification from Department of Labor and you file it with the USCIS. If you're approved, then you can move on to Department of State and file for the actual visas. There are more steps, such as recruitment, involved in the Department of Labor step before you get your certification, but we'll kind of delve into that a little bit later when we talk about recruitment and things like that. So there are a few more steps involved with Department of Labor before you get to USCIS, but that's kind of in a nutshell the general steps.
Thank you so much, Megan. Those are really good points to keep in mind. And thank you so much for highlighting, especially the documents required. So thank you so much. Folks out there, I know you are excited as well. Thank you so much for joining us. I'll quickly say hello to Tanya and Nishtha, who have commented with their questions. Please stay with us. We are going to take them up a little later. So, right now, another question I have for you, Megan, and that is, how does an employer demonstrate that
Mhm.
there are not enough US workers who are able or willing or, qualified and available to perform the temporary work as required by the H-2B program?
Sure. So that is what I alluded to a little bit ago with the
Yes.
additional steps that are really happen between filing your temporary labor certification application with Department of Labor before you get certified. There's something called recruitment. Um, at this point, the recruitment, every employer, once they get their notice of acceptance, they will, meaning that the government hasn't asked for any additional documentation. The government could issue what's called a notice of deficiency asking for more information. But if they don't do that, you get a notice of acceptance and then starts recruitment. The recruitment process is how the government essentially asks each employer to test the US labor market to ensure there are no qualified US applicants who can fill these roles. There, the recruitment period lasts 15 business days for most of these steps. However, every employer still beyond this recruitment period, at the close of which, at the end of the 15 calendar days, the employer will file a recruitment report which details every US applicant, how they applied, whether or not they were hired, the outcome of that interview, if there was one, if they're able to reach them. Based on that recruitment report, the government will then certify the employer for either the full complement of H-2B workers requested, or they will reduce that number based on how many U.S. hires they make. So if you're asking for 10 H-2B workers and you are able to hire 2 U.S. workers, then you've proven to the government that there are 2 qualified U.S. workers. So your true need is only 8 workers. But in order to get to that process, there are a number of recruitment steps that every employer must take. The first of which is an internal posting notice in their job at the job site. So whether that is a break room or an HR office or a primary office, at least 2 spots at the place of employment must post this H-2B job order. So that would have the terms and conditions of the H-2B position, any job description, title, location, deductions, benefits, all of that information is required in this job order that gets posted at the work site. Now, in addition, that same posting, the same content at least, is posted on the state workforce agency. Every state has a different process for posting jobs that are available to local candidates. Think of it as like Indeed, but it's run by a state. So these postings get put online with the state workforce agency, and every employer must field applicants that are interested in the position. Another required recruitment step is, which again protects U.S. workers, is every prior U.S. worker that employer has had in the past year must get a copy of that job order so that they know they're hiring for that position again. The only exclusion would be workers that were terminated for cause or workers that quit or abandoned the job. So those workers would not get a letter, but other U.S. workers that may have worked seasonally in the past year would be entitled to know that this job is open again. Another item that could be by phone or certified mail is the best way, so the employer is protected and you can prove you've sent it to them, the last known address. Another less common recruitment step is if the employer participates in a collective bargaining agreement, they must publish that job with the CBA representative so that it's advertised across the organization. If the employer has a website or somewhere else internally, an intranet, they normally post jobs, that would also be somewhere that would need to have the job posted. If they have one. If they don't have one, it's not something that they need to create for the purposes of H-2B. It's only if it's normal course of business for them to post jobs in that manner. The last part of recruitment is performed by Department of Labor. Department of Labor will post the job order on seasonaljobs.gov and make it available nationally so that anybody who's looking for H-2B jobs or anybody that's looking for a job it'll come up on a search. So if someone searched landscaping in Richmond, Virginia, it may come up. It would be available on that website. So the last component that is important for U.S. workers is to know is that this job rec, even once that 15 calendar or business days have passed, while it won't impact the number of workers the employer is able to get with H-2B, they do need to continue to accept U.S.-based applicants up until 21 days before the start date. So it's not going to impact their H-2B worker count, but they do still need to field U.S. applicants. They are obligated to do so. Again, the purpose of that is just to ensure that there's no additional opportunity afforded to foreign workers over U.S. workers.
All right. Thank you so much, Megan, for for the detailed explanation and helping us with the answer for that. Thank you so much. I have this next question for you.
Mm-hmm.
So, what is the current cap on
Mm-hmm.
H-2B visas for fiscal year 2025, and how can an employer access the additional supplemental visas announced by DHS?
Sure. The annual quota for H-2B has been 66,000 since the 90s. And it's divided into two halves. The first half of the government fiscal year on October 1st, is allotted 33,000. The second half of the government fiscal year, which opens on April 1st, is also allotted 33,000. The demand far outpaces supply for those initial visas year over year and has for a decade. So in 2017, they started issuing what are called supplemental visas. They are not in the regulations. They're not guaranteed, but the government does have the ability to issue additional visas if they elect to do so, if they can agree to do so. This year, they did announce that they will issue almost 65,000 additional visas for this fiscal year. However, the text is not yet available for the 2025 fiscal year, but if we assume it's the same as the past two fiscal years, which it has been largely the same as far as eligibility and compliance, then we can expect it to be broken down such that A portion of those additional visas will be allocated to the first half of the fiscal year and what they call returning workers. So if you've never had an H-2B, you're not going to qualify for the supplemental visas under returning worker exemption. Those are workers that have had an H-2B at least one time with any employer in the past 3 government fiscal years. So if you have worked for anybody, you would be eligible if your employer wants to file for supplemental visas. So again, that is just a little bit of a security net for employers that miss the initial cap, that they have a second opportunity to try and take advantage of the H-2B visas for this year. There's also an allotment similar to that for the spring. In other words, if you miss the cap for April 1st in the spring, again, if you have workers or know of workers that have had an H-2B at least once in the past 3 years, they would qualify as returning workers. And there will be visas in the spring as well in that same category. Additionally, the spring has another category of returning workers. Typically, that is reserved for late season H-2B employers. So if your start date of need is not April 1st, if it's May 15th or later in the year, there's a separate carve out for supplemental visas in that for returning workers for those dates for those employers. The last option for supplemental visas is what used to be called Northern Triangle. Now it's called country-specific allocation. It is open to workers from a specific set of countries that have never held an H-2B visa, but employers, there's a brand new cap from these supplementals. So if the employer will take recruits from this subset of countries, then there's a whole extra 20,000 visas available to employers who will recruit from these separate countries. Those are Haiti, Honduras, El Salvador, Guatemala. They just added Costa Rica, Ecuador, and Colombia last year. And so I think I might have missed one. Honduras, I think I'm not sure I've said that already, but those countries are a great option for employers who don't have returning workers and have missed the cap. Because the nice thing about that part of the supplemental visas is in the years that they've been offering those, that cap has not been hit to date. As there's first year for everything, but those are a more reliable and a little less risky pool of visas to pull from because they have been more open.
All right. So, yes, thank you so much, Megan, for saying that for us also and for the detailed explanation. Well, maybe you could highlight also, how the H-2B is different from the other employment visas,
Oh, sure.
for folks out there who want to know where can they categorize themselves.
Right. So, as we know, there's an alphabet soup of non-immigrant visas available. All of them have their own eligibility requirements and stipulations. H-2A, those who are going to qualify for H-2B probably will qualify for H-2A from the worker standpoint. Employer standpoint, that's reserved for agricultural companies, employers that work in the agriculture section. It may be farms that do produce. It just depends. There's a lot of agricultural employers that take advantage of H-2A. There are other visas, so H-2A and H-2B generally don't require degrees. It's not necessarily true across the board, but it is the only category that's going to have people, without any required specific training. There may be experience or training requirements employer to employer, but overall, if you're from a country that's on the eligible country list, which you can find online, there will be ways for you to get seasonal employment if you don't have a degree. Those are what H-2A and H-2B are really good for, as far from a worker standpoint and from a prospective visa holder standpoint. There's TN visas if you have a degree that, if you're from Canada or Mexico, there's a whole list of occupations and there's no cap for TN. So if you have a degree and you're from one of those countries, or if you're, an employer looking for a particular occupation that falls on the TN list, that's a great way to, have workers come in that way.
Mhm.
TN, there can be some crossover for some of the occupations that are very similar to the kinds of roles that you may want for H2B. For instance, a landscape architect would fall under a TN, or
Mhm.
veterinarian or an animal breeder or something like that that's related to farms, but maybe you need someone with more skills, more training.
All right.
Um, so something like that. And there's a
Mhm.
whole host of other visas I could go over. I don't know how many of them you'd like me to talk about.
But yes, thank you so much. Thank you so much for highlighting those differences of the H-2B and other employment visas. Thank you, Megan. And Megan, we have a viewer who has joined us. So nice of him. This is George from Nigeria. Really happy that you have joined us. So we would love to take a couple of questions from George if he has any. So control, if you could just let him in. Um, yeah, please ask your question. George, are you there?
Yeah, can you hear me?
Yes.
Yes, we can hear you now. Great.
Okay. Um, the question I was gonna ask had to do with um, you loosening up a little bit regarding your policies. Um, like I said yesterday, everyone does not have to come to America. Okay.
Mhm.
If the government actually loosen up a little bit, let's say, just like what you're talking about, they have quarters they're giving for H-2B visas. So if you have search for remote, you tell the companies, look, you can get anyone outside of this country. They don't have to come to America, but they're going to be working on the remote basis, right? And
Mhm.
before you have to pay their salaries, then do what they call tax deduction from the salaries before you pay out, right? So I think if that would be looked at, it will be a very good idea, because one of the reasons why you have the Americans coming up with several immigration policies is because you have a lot of people
Can you hear it? I can't hear.
I think, yeah.
papers or documents are being expired, and then they also want to continue the work. Can you still hear me?
I
Yes.
missed that middle part.
Yeah.
I heard that if their documents are expired, but I missed a part
Hi,
of
can you
that.
hear me?
Yes, we can hear you. Could you just repeat the part where just some time back you were saying? George, are you there?
Yeah, I'm
I
here.
think
So
okay.
did you get what I said?
No, we didn't hear the question part. I'm sorry.
Could you just repeat your question, please? The question you just asked some time back. George, if you're still there.
Yeah, I'm here.
Uh, so sorry, we couldn't get your question. Could you just tell us what your question was?
Okay, the question is, can American government look at, loosening up a little bit and allowing companies, independent companies, actually employ people from other countries without they coming to America and, the American government providing some sort of tax identification number for remote workers. I think if you encourage that, that would actually strengthen the job quality you have over there, and also
The government here in the U.S. has been very apprehensive about changing policy. I mean, like I said, just in my experience with H-2B, the quotas have not changed since the 90s. So while there may be many ideas that would be beneficial to both the U.S. economy and workers abroad, I would not expect there to be any meaningful change or positive additions to immigration, particularly with the upcoming administration change. I would not expect that to happen right now. That's not to say it would never happen, but I wouldn't expect a tremendous amount of change, at this point. There are many other countries that allow, such as things like digital nomad visas, where they can come work remotely from their home country in the U.S. and do things like that. We don't have anything like that here. Our immigration categories have been fairly static for quite a long time. We have not had comprehensive immigration reform since the 90s. And with the polarization of this topic overall, from an employment and family-based side, I just would not expect there to be any change. There may be many great ideas that people could bring to the table, but adoption or passage of that would be very difficult in this climate.
Thank you so much for taking that up. And George, do you have any other questions? George, are you still there? All right. Thank you so much, Megan, for taking that up for George. I think
Sure.
there might be some network issue, but I hope George got the answer he was looking for.
Sure.
And if he has any further questions, I'm sure George will drop them in the comments or maybe rejoin us soon.
Sure.
Meanwhile, I think let's take up Tanya's question. I run a small landscaping business and want to hire workers for our business busiest season. How do I start the process of sponsoring workers under the H-2B visa? And are there specific forms or steps I need to prioritize? I think we touched on this earlier already, but if you could just
Yes.
highlight, yeah, anything.
Yes. If it's landscaping, I would assume your busiest season would fall in the spring. So at this point, the first step is starting to file a prevailing wage application with Department of Labor. That's the very first step required, no matter where you're filing, what position you're filing. So you just need to know what position you're filing for and get that application lodged with the government. You can't move on to any other step if you don't do that first. So you should find someone that can file that for you. I have a great number of landscaping clients. So I'm very familiar with that process from start to finish. At this point being mid to late November, it would be very tight to try and get that filed for next spring. Unfortunately, it's not impossible, but timing would really have to work out in your favor. That's the first thing you need to prioritize. And if the only other thing I can say that is, if you have workers you want from a particular country, make sure they're on the country list. I get a lot of questions that say they know somebody from X country and that country is not eligible for H-2B at all. So if you're wedded to one particular person, make sure that they qualify before you bother starting the process.
Great. Thank you so much for taking that up for Tanya, Megan. Thank you so much, Tanya, for participating with your question. And well, I have more questions lined up, but let's take up Nishta's question first. I've worked under an H-2A visa before. Can I apply for H-2B visa next, or do I need to wait for a certain period of time before reapplying? Uh, And how soon can I reapply for an H-2 visa after my current one expires? Is there a limit or on how many times I can apply?
Mm-hmm. Okay. So the answer is it depends. For part of that. So if you have been on an H-2A visa, whether or not you can apply for the H-2B visa, it just depends on how long you were here on the H-2A visa. So one of the eligibility requirements for H-2 workers, whether that's H-2B or A, you have up to 3 years of H eligibility, at which point, if you enter, say, January 1st, 2020, then your H authorization would have expired in January 2023. So you have 3 full years of eligibility. You can reset that by, if you've been outside the US for 3 consecutive months, then you reset your H time and you get another 3 years. So there's no limit to the number of times you can be on an H-2 visa, A or B, but there are time limits for each stay. So if you were to come in, like I said, say April 1st, and you change employers, so you're never out of the country for more than 3 months, then you're going to be limited to 3 years. And at some point during that 3 years, you need to reset. You need to be outside of the US for 3 months to get more H time. And that, you can certainly have an H-2A visa, go home, get an H-2B visa, and come back. That's fine. You can do both. There's nothing to preclude you from participating in both programs. You just need to make sure you're aware of what your limit is and make sure that you've been out to reset that clock at least for 3 months if you're here for that long.
Okay. Okay. Thank you so much for taking that up for Nishta and for the detailed explanation, Megan. And now we have Samuel. Samuel is on YouTube. He also has a question asking administrative processing in H-1B visa for 9 months. What can be the cause?
There is not very much transparency for administrative processing. For instance, if I, as the attorney, email the consulate and ask, why is this an administrative processing? What do you need from me? What do you need for the worker? They will give me a canned response that just says it's an administrative processing and we'll contact you if we need anything. There could be a whole host of reasons why you might be in administrative processing. Your name, it could be something as simple as your name is similar to someone who has some overstay issues or a travel issue or is on a list somewhere, flagged in the system. It could be that you've overstayed. It could be that they're unsure of your intent to return home. That's called, immigrant intent. They could be questioning whether or not you will stay permanently if you're issued the visa. There's a whole number of reasons that we'll probably never know the answer to, unfortunately. For instance, I just had someone try to process in South Korea, and she has no red flags. She's no criminal history, one prior U.S. visit. There's nothing on paper that should have precluded her from being issued a visa, but she was put in administrative processing briefly, and then, certainly not 9 months. But the reason they gave ultimately for being refused was that they questioned whether or not she would return to her home country at the end of the visa. There's the consular officers are given a great bit of discretion to review the applications, and they don't give us a lot of transparency. I said South Korea for that process. So, there can be and this would come up from any country, anybody from any country on the eligible list. And sometimes there's a surprise like that. For instance, that client, it was a surprise to have that happen. There were no indications prior to going to that interview that there would be any issues. So I wish there was some way to find out why you're in administrative processing.
Right.
But there's not very many good ways to do it.
All right. Thank you so much. Thank you so much for taking that up for Samuel. Samuel, if you have any further questions, you can keep commenting and we'll be addressing them very, very soon. Thank you. And now let's take up Mukesh's question. This is also on YouTube. He asks, if our company hires an H2 worker who doesn't show up, what are our obligations and potential liabilities? And what happens if an H2 worker gets injured on the job? Are we liable?
So I'll take up the first part of the question first. So if you have H-2 workers and someone disappears, they abscond. That's typically if they haven't reported to work for 5 days, they have been non-responsive, they're AWOL, they've been absent without leave for at least 5 days. You can report them as an abscondment. So, and you are required to report them if you know they're not coming back. For instance, if they've quit or left in some way, and they're not coming back, and you haven't given them permission to leave. People leave all the time, but your obligation as an employer is within 2 days of knowing that they're not coming back. So they told you they weren't coming back, or it's been 5 or more days, and they haven't reported to work. No one knows where they are. You can assume that they've absconded. You have to report the departure to the government. You have to report it to Department of Labor, and you have to report it to Immigration Services. That will insulate the company from being on the hook for the 3-quarter guarantee when the worker's not there. So that's one of the compliance requirements. We didn't get a chance to get into those today. But from on the employer side, one of the requirements is a 3-quarter guarantee, meaning that it's a full-time position, 35 hours or more. You have to, as an employer, offer them at least 3/4 of those hours offered, whether you say it's 35 hours or 40 hours. If you have to report them as missing or absconded, or if you fire them, you still have to report them as an early departure. It's one of the compliance requirements is to report a missing worker. As far as workplace injury, that falls outside of the scope of immigration, and it's going to be based on your state law, whatever your state workman's comp is. You would be liable in the same fashion as you would a U.S. worker. So if would be liable for workman's comp for a U.S. worker, it's going to apply for an H-2 worker. Now, on the worker side of that, if they're injured on the job and need surgery and can't travel and the end of their visa is coming, they need to look at changing it from an H-2 visa to a B visa, a visitor visa, and do a change of status so that they're not here unlawfully on the H-2 because they're no longer working. So it comes up in rare cases, but yes, if someone's injured, they need to make sure, and they can't travel home for treatment, we have to be able to make sure they stay in status.
Right. Thank you so much, Megan, for highlighting and for giving us such important points today. And thank you for also taking up Mukesh's questions at the same time. Thank you, Mukesh, and you can keep commenting if you have more questions. Now, coming back to our questions, Megan, I have
Sure.
another question, and that is, what are the robust protections in place for
Mhm.
both American and foreign workers, under the H-2B program, and how
Mhm.
must employers ensure that these protections are met?
Right. So there's many protections for both U.S. and foreign workers. On the U.S. side, there's basically it boils down to making sure that a possible U.S. worker is not treated in any less fairly or afforded any fewer opportunities or no more requirements than would be required of a U.S. worker. For instance, if filing a landscaping position, a corresponding worker couldn't be required in the U.S. to have 5 years experience when you require 0 experience for a foreign worker. So, each business, when they file the application with the Department of Labor, has to sign an attestation with all these compliance requirements listed, noting that they understand what those requirements are and that they will abide by them while they're participating in the program. Now, workers, to start out with, for corresponding workers or foreign workers, they should get before they start, or if they're a corresponding worker and they may already be working, because that could be a worker that's worked for a year or less with the same employer. So again, corresponding worker means it's a U.S. worker either present, already working, or one that you hire during the recruitment process that performs substantially similar duties, same job. That would not be your secretary or your landscape manager if you're coming in as a groundskeeper. If you're just doing a landscape laborer job, corresponding workers on the U.S. side would be the same position, not something that's unrelated. So again, the employer can't impose any requirements or obligations they wouldn't impose on the H-2B worker, and they also, have to pay them at least the same as they're paying the H-2 worker. Now, anyone in the H-2B process, which is going to apply to corresponding workers as well as H-2B, because if you have H-2B, then you have corresponding workers more than likely. A big component is prevailing wage. That prevailing wage is the first step. I talked about the employer process, but it's important for the workers because when you get the terms and conditions of employment before you start, which tells you what kind of job you're applying for, where it is, who you're working for, what the wages are, whether or not there's overtime, what benefits are included, all of that is given to you. So you can track it. You can make sure you're being paid what you should be. And that includes the prevailing wage. Every position is set by the government, and you have to at least make the H-2B prevailing wage. So you get that protection. Also, in H-2B, you're going to need to be paid at least every 2 weeks. They can't pay you once a month. There has to be regular paychecks. It's another requirement. On that same note, Every employer is required to provide you with a pay stub, which provides you with the hours offered and the hours worked, the pay rate, overtime rate for every pay period. So that should be something that you get. Also, deductions. Unlike H-2A, which does not have to have with tax withholdings on it, H-2B does have tax withholding. So your federal taxes and Social Security withholdings are withheld from your paycheck as required by law. But any other deduction aside from those lawful, required deductions, the employer has to have your approval to deduct it. So if you, one difference between H-2A and H-2B is that H-2A housing is provided, H-2B, the worker is responsible for their own housing. That being said, some employers will give workers the option to stay in employer housing, which means you pay fair market rent and utilities. If you are opting into that as a worker, you have to either pay the employer directly, or you can have it withheld from your paycheck. So things like that, health insurance, rent, utilities. Let's see, what's another common one? Loans, things like that could be a deduction on your paycheck need to be approved by you. And they need to be on your pay stub so that you can see what the deduction is. So, you just need to know what's coming out of your check, and you're entitled to know that. I talked a little bit earlier about the 3-quarter guarantee on the employer side. It's another thing for employees is that H-2B is a full-time role. If you are offered 35 hours on your contract, you are entitled to at least 3/4 of those. If you're offered 40 hours, you need to be offered at least 32 hours, so you've got some minimum protections to make sure you're not doing nothing. You're getting paid for the work that you expected to be here to perform. And if they don't have enough work, they're still required to pay you for it. If it's rained, and it goes for every 12-week period. So there's a calculation for that you can look up. The employer should be aware of, that's an important guarantee to make sure you're paid as the contract says. Another important item that comes up is tools and equipment. There's no reason you should be charged for tools and equipment. That the employer provides all tools and equipment to perform the job. So that should not be something that happens. Another important note for protection for workers is visa fees. There's under no circumstance should the worker be paying for visa fees. You may pay them at the consulate. Some employers will do that, but you have to be reimbursed the first work week when you get here. Inbound travel, also something that is covered by the employer as part of the H-2B program. That one is most employers will prepay it for you. Some may pay it when you get here. The regulatory requirement is that as long as you stay, you have to stay for half the employment contract to get the inbound transportation. But with federal wage requirements, a lot of times they just pay that with your visa fees up front because they can't take you below the federally mandated minimum wage by virtue of withholding that, by not having you reimbursing that travel. So the bulk of you will have your travel reimbursed when you get here, if not prepaid. Same thing. If you complete your contract, you do not leave early. You're not terminate. You're entitled to have the employer cover your return transportation. So you finish the work contract at the end of the season, your employer is responsible for sending you back to your point of origin. So that wherever country you came from, you get travel reimbursement back to your home. Very important. Same thing if you're terminated, you still get return transportation. The only time you don't get return transportation is if you quit early, or if you transfer to another H-2 employer, then that new employer is responsible for paying your travel to the new employment site. So those are very important. Another very important thing that workers should know, and this comes up not in the employer context, it is an employer compliance requirement. Employers should sign something if they're using a recruiter, the employers should have something signed that the recruiter says that they're not going to charge workers a fee. No H-2B worker should pay an employer or a recruiter a fee to be referred to H-2B. Very important. It's not something that you should be responsible for. And violations for this, there are audits from Department of Labor, there are site visits, inspections.
Mhm.
Employers are required to maintain an audit file with all of this documentation, copies of your pay stubs, copies of reimbursements. The employer should have copies of all of this. And workers also, there should be an H-2B rights poster that the employer posts in the worksite. That also will have details on how you can whistleblow, how you can report it. There's anti-retaliation components as well, so that the employer can't retaliate if you report wrongdoing or mistreatment.
Wow. Those are, I mean, a great number of protection rights and laws and rules and regulations you highlighted. And thank you so much, Megan. I think
Sure.
once you have the passion to work and you have the right documents and you're on the right path, I think nothing can stop you.
Right.
So thank you, Megan. And we have Samuel who's back with another question. I think we should take that up. He's asking, can my spouse, who is my dependent on an H-1B visa that is in administrative processing, apply for a visiting visa?
There's nothing to preclude her from doing so.
Okay.
But again, there's very little transparency into that application process. So, it's possible for a spouse to also be put in administrative processing for anybody can be put in administrative processing for any visa, for them to review it. But there's nothing, just because you have a visa pending, that also doesn't mean she couldn't apply for her own H-1B, her own visitor visa. There's nothing to preclude, again, assuming she's eligible or can qualify. Your being in administrative processing isn't going to prevent her from doing something else. Even if she's on an H-4, she could still theoretically apply for a visitor visa.
Mhm.
Whether or not
Cool.
it's approved, is anybody's guess.
That's cool. Thank you so much for taking that up. And Samuel, I hope you've got your answer. Thank you for participating. I have another question, Megan, and that is, how does the H-2B program ensure that foreign workers are not exploited by the employers?
Right. So that a lot of the same things will apply from the compliance requirements. All of those compliance requirements are in place so that workers are not exploited. You have a prevailing wage to ensure the worker is not paid too little. There's, again, reporting opportunities with Department of Labor to report employers that are misusing the program, so that your protections remain in place. There's also, depending on your state, there may be nonprofit or volunteer groups that can also provide services to help if you are being subject to mistreatment. So all of these protections and compliance requirements that you should be entitled to, they can be enforced in the same way. Though you can report them and they can be subject to penalties for that. And I don't know if we'll get to the penalty question or whether I should cover that here, but there are penalties that the employer can suffer based on that, depending on what the violation is. Again, the anti-retaliation requirements are important for that. Workers can file a complaint with the Wage and Hour Division with Department of Labor for any of those violations, for being charged a fee, not making your hours, not being paid the correct wage, being denied. Again, another thing that doesn't come up often, but when there's severe negligence or mistreatment of workers, another thing you should report absolutely is if your employer is holding your passport. Your employer should not have your passport or visa. You should have free autonomy to leave at any time. Be aware of as a worker, the terms and conditions of your visa, and make sure you're not, by leaving, having an issue with your status because you're no longer at the employer. So, there are things to consider for that, but it shouldn't deter you from reporting mistreatment.
Right.
I don't know if you want to jump ahead to the repercussions for employers. I know that's another question, or if I should just get to that later.
Yes, we could get to that a little later, or maybe in our next episode as well, because there's so much to talk about H2B. But
Sure.
I would also like to tell our folks out there, that it's always best to consult an attorney and be guided with your case, because every case is different and needs proper attention. And I would say, why not contact attorney Megan Kirkner in her number, and her number is 434 226 0586. You can note it down. You can also email Megan. Her email address is Megan at kirkerimmigration.com. You can check out the spelling on the screen and go visit www.kirknerimmigration.com to get to know more about Megan. Thank you so much, Megan. It was really great. But of course, I mean, so much to talk about this. I
A
think
lot
we
to talk
should
about.
definitely do another episode on H2A and H2B visas again.
Sure. Be happy to have
Yeah.
you.
But before we go, what do you have to say about Trump and, starting 2025? What can we expect, maybe, or what do you think the immigration scene is going to look like?
Uh, I was just at a conference in DC with other immigration attorneys on Friday, and we're all just ready to buckle up for the ride. H2 in particular was a little more insulated from some of the trials and tribulations that came from the administration last time. A lot of the other employment visas, family based visas, are going to have much tighter scrutiny. Requirements may change. It's going to be more difficult. If, again, I know you mentioned a lot of people file on their own, but with this, particularly with this administration change, having an attorney navigate the process will be more important than ever because it's going to change and it will change quickly. And more than likely, not in any way that makes it easier.
I know everybody is so anxious, and I really hope that things fall in place as soon as possible, or at least folks out there get to know what can happen or what may happen with their case. So thank you so
Right.
much, Megan, once again. It was great
Mhm.
having you, and I really hope to see you in the coming week.
Nice to be here, and thank you for having me. And best of luck to everyone watching. And reach out if they have any questions.
Yes, absolutely. Thank you so much. And also Samuel, and then we had George who had joined us. Unfortunately,
Mhm.
the line was a little disturbing, but I still hope that, George, if you have any further questions, you can comment, because after the stream has ended, this is going to be published, and it'll be really nice to have you comment with your question. And I'm sure, Megan, you can address that. I will I will put that up to you.
Yeah,
You do,
sure.
yeah. Anything else you want to say to the folks out there with regard to the topic before we leave them? Because I feel like we're just ending it so abruptly right now.
Yes, where this is just a tip of the iceberg for the H2 world. I wasn't really able to dive in at a really granular level as far as what employers need to do, how long it takes. So
Yes,
I really just want everybody to know that it can be a long process, but with the right help, and starting at the right time, it doesn't have to be a painful process as long as you start. But there are timelines are critical for this program.
right, right. Thank you so much for that hopeful note and an end note. Thank you, Megan. And you have a splendid week ahead, and I'll see you soon.
You as well. Thank you.
Thank you. And folks out there, thank you so much for joining us on YouTube, LinkedIn, Facebook, and Twitter. It was really nice having you, and especially with your questions in the comments. So feel free to like, share, and also subscribe to our channel. Hit that bell icon so that whenever we have discussions like these, you are notified. And really, I'm also looking forward for Megan to join us again in the coming week, because there's so much to discuss about H2 visa, and I'm sure you too have a lot more questions. So thank you so much for doing this today, and don't go anywhere, because we have more webinars and discussions lined up on Immigration and Jobs Talk Show. This is